court. The clerk will open the court.
Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Good afternoon. The COVID-19 pandemic has required many adjustments of the justice system. Social distancing and group size restrictions, as well as substantial hardships on counsel traveling to Austin, do not allow us to hold arguments in the courtroom. Rather than submit cases without argument, we have decided to proceed through remote connections. Court staff has made every effort to prepare us and counsel, but of course there may be glitches that will require patience. Otherwise, we will proceed as we would in person. The arguments are being live streamed this afternoon and a recording will be available later today. We are ready to hear argument in 2394, In re the State of Texas, a petition for writ of mandamus to the Harris County Clerk and certain other election officials. The court has allotted 25 minutes per side for argument.
May it please the court. Mr. Hawkins will present argument for relator. Relator has reserved 5 minutes for rebuttal.
General.
Thank you, Mr. Chief Justice, and may it please the court. The state asks the court to exercise its mandamus authority to compel the respondents to comply with their statutory duties and the vow they took to defend and faithfully execute Texas law. I'd like to make 3 points today. First, the legislature has allowed only a small subset of voters to vote by mail, and the language the legislature chose in the disability provision of Chapter 82 does not include otherwise healthy individuals who would prefer to avoid going to a polling place. Second, mandamus relief is necessary here because the respondents have promoted an incorrect view of the law that will lead to countless improper applications for mail-in ballots. And they have done so mere weeks before an election. There is no time for this dispute to percolate through the lower courts. Indeed, Harris County's brief explicitly concedes that this court is the proper venue to resolve this dispute at this time. Third, the governor of Texas and the Secretary of State have already taken concrete actions to ensure the safety of in-person voting, and they are working to do even more as we speak. The judicial branch should not rewrite the election code out of policy concerns that are already being addressed by the executive branch. I'll begin with the text of the statute. Section 82.002 makes voters eligible to vote by mail if they have, quote, a sickness or physical condition.
Mr. Hawkins, may I ask you, please?
Yes,
if we accept your argument is true, and that is that it would be improper for the clerk to send a person a mail-in ballot simply because they are afraid that they would get COVID because they have not developed an immunity to the virus, how would that be monitored? Are you suggesting that the clerk would go out and investigate this claim?
Not at all, Justice Lehrman. I'd like to be very clear about what we are asking the court to do.
Thank you.
We are not asking the court to order county clerks to investigate every application for mail-in balloting. We're also not asking the court to order the clerks to look behind those applications. What we're asking the court to do is to order the clerks to comply with their statutory duty in 86.001C to reject applications from voters who are not eligible to vote by mail and therefore not entitled. Now,
how would they know that if they've checked that they're disabled?
So, Justice Lehrman, if the face of the application, the four corners, is properly filled out and disability is checked, that's the end of the inquiry. We're not asking the clerk to look behind that. But if the voter has, consistent with what the respondents here are advocating, written in extraneous information onto the mail-in application, indicating that that voter is otherwise healthy, but simply susceptible to disease or afraid of catching disease, then that application must be rejected under 86.001C. And that's where the disagreement is between the state and the county respondents. They're saying—
General Hawkins,
Yes, Justice Boyd.
the applications that are included in the exhibits that were filed with the court, I don't see a blank where they can add in any extraneous information. I mean, I know that they can submit an informal application and they don't have to use the pre-approved forms. But if they use the pre-approved forms, and I saw several different versions of them, all very similar, you know, you check box 5 and you check box 6A, but there's no place to add any extraneous information explaining why you think you have a disability, nor are you ever asked to do that, nor do any of the instructions even address that.
Justice Boyd, we understand that voters sometimes write in extraneous information anyway, and that's probably because they are people of good conscience who recognize that they don't actually suffer from a disability. They check the disability box, recognize that that doesn't match their actual experience, and then right next to that, fear of catching disease, desire to stay at home, something else like that. Now, yes, Justice
Mr. Hawkins, who decides whether a voter qualifies to claim a disability, the voter or the clerk under the statutory scheme? Who makes that initial decision?
So the statutory scheme is set up such that the county clerk must review each application, and if within the 4 corners it's valid and that clerk has no extraneous information that the voter is not entitled to vote by mail, then the clerk should approve that.
But isn't it the voter in the first instance who's going to make that decision about whether or not they have a disability because they're completing this ballot?
That's correct, Justice Guzman, but of course the voter is constrained in completing that application by section 84.0041 of the election code and by chapter 276 of the election code, subsections 013 and 014, which impose criminal penalties on providing false information in connection with applying to vote by mail, filling out a ballot.
Do you believe that a voter that has a pre-existing condition like diabetes or some other autoimmune disease qualifies as having a disability under the statute?
So, Your Honor gave a hypothetical involving a voter who has diabetes. I think diabetes, Justice Guzman, is a clear example of a sickness within 82.002. I think we would all agree that that is a sickness. That's a medical problem. And so that voter clears the first hurdle in 82.002 and then gets into the second question about whether there's a likelihood that voting would lead to an adverse health effect.
Go ahead.
I'm sorry, Your Honor. Of course, that's not what this case is about. The case here involves the respondents telling otherwise healthy voters who don't have a sickness and don't have a physical condition that they can nevertheless vote by mail if they're simply afraid.
So that's what you want to enjoin, their speech, their ability to, there was some assertions in the briefs that they were broadly telling voters that they could vote by mail. Do you seek to enjoin that activity? It wasn't clear.
So, Justice Guzman, we're seeking to enjoin 3 specific things, and they involve more conduct than speech. Let me lay them out very carefully. Number 1, we ask the court to order the clerks to comply with their duties in 86.001C to reject applications from voters who are not eligible or entitled to vote by mail. Number 2, we ask the court to order the clerks to comply with the duties imposed by Chapter 84 and Chapter 276 of the Election Code. Those provisions proscribe broadly encouraging the provision of false information or facilitating false information or invalid claims. And then third, we ask the court to order the clerks to comply with the constitutional oath that they all took in Article 16, Section 1A, to defend the law and faithfully execute their duties which means to cease providing voters with incorrect information on their websites and their amicus briefs, things like that, and to correct their previous misstatements. Those are the three specific things that we're asking for today. If I might.
Would you say that if the clerks take it upon themselves to explain how election law works to the voters and how the early voting law should be interpreted, if they take it upon themselves to explain that to the voters, do they have a legal duty to get that right?
That's correct, Justice Blacklock. We think that flows from Article 16 of the Texas Constitution. If I may, I'd like to go through our statutory interpretation argument. I made this point in passing with Justice Guzman a moment ago, but I'd like to flesh it out more carefully. No one claims that susceptibility to disease counts as a sickness. The other side, of course, is instead arguing that susceptibility to disease counts as a physical condition within the language of the statute. But that cannot be correct for at least three reasons. First, physical condition cannot mean lack of immunity to disease, because that definition would sweep in every Texas voter. Every single voter in Texas is susceptible to one disease or another, whether it's the common cold, whether it's seasonal influenza, whether it's something else. If the legislature wanted to make everyone eligible to vote by mail, it would not have gone to all the trouble of enacting 82001 about absenteeism, 82002 about disability, 003 about age, 004 about incarceration. Instead, it would have done what over 30 other states have already done, which is simply pass a statute saying that anyone who wants to can vote by mail. More than 30 states have done that. They've shown our legislature how to do that, and our legislature has declined to do that. The respondents have to accept that policy choice of the legislature not to go that far. Second, we have to read the term physical condition holistically with the rest of the statute, including the statutory heading. And no one would say that someone who is susceptible to a disease suffers from a disability. Again, that would mean that every voter is disabled because every voter could catch one or more illnesses. As this court noted in 2010 in the United Services case, the heading gives some indication of the legislature's intent. Third, the word condition in this context is best understood to mean some sort of anomaly or medical problem. And we cite dictionary definitions to back that up on page 13 of our mandamus petition. Again, a generalized lack of immunity to a disease is not a distinct medical problem the way, for example, being paralyzed is a distinct medical problem.
Mr. Hawkins, the Harris County says that definition of physical condition just makes it mean the same thing as sickness. What's your response to that?
That's not correct, Justice Busby. There are many physical conditions that we think fall within that category that would not count as sickness. So for example, Justice Busby, if I were to break my leg in a skiing accident such that I couldn't go to work and I had to call my boss and tell him about that, I wouldn't say, boss, I can't come in because I'm sick. I would say, boss, I'm unable to come in because I broke my leg. I've got a physical condition that prevents me from going to the office. So in that sense, we're not asking physical condition to be read the same as sickness. There are many ailments that people can have that would be sicknesses or physical conditions that are different.
Isn't everyone kind of directed right now not to go to the office?
I'm sorry, Justice Bland?
Isn't everyone kind of directed right now not to go to the office?
Well, Your Honor, the governor
like not without a broken leg, without some other, just don't come to the office. There's a risk.
Well, Your Honor, the governor has issued a number of executive orders that impact what types of businesses can be open and what types of capacities, and that's constantly evolving. But none of that impacts the statutory interpretation question now before the court, which is whether a generalized fear of illness or whether a generalized lack of immunity to illness constitutes a sickness or a physical condition. Now, the other side
has the Secretary of State directed the clerks that if a voter checks disability, that they must issue the ballot. So is the Secretary of State's position that if disability is checked, the ballot should be issued. And do you have any issue with the Secretary of State's position?
Not at all, Justice Bland. The Secretary of State's guidance that the other side cite in their briefing is fully consistent with what I said a moment ago, which is that if a county clerk receives an application and within the four corners of it, it's valid on its face and there's no other information the clerk has that leads the clerk to know that this person is not actually eligible, then the clerk should approve it. And that's the guidance that the Secretary of State has given. And that's what the state is now representing today. That's different from the situation we're faced with here, though, where the county clerks are nevertheless saying that they will process and approve applications from voters, even when there is extraneous information indicating that that voter is not eligible.
How do we
Has
know
there,
that
has there
from the
been such
record,
an
Ms.
application? Has there been such an application that a clerk has rejected or accepted?
Well, Your Honor, we take them at their word. They're insisting that they will do that. Now, of course, these applications don't come to the state, so we don't have them. We can't put them in a mandamus record, but I take the clerks at their word that that's their view of the law and that's how they go about doing their jobs. And of course, we think that's contrary to their clear duties in 86.001C. I'm sorry, Justice Busby, I think I cut you off.
Dallas County has said that in order to get mandamus, you need a predicate request and an erroneous refusal to act. So have you requested that the county clerks disregard any extraneous information on the, or take into account rather any extraneous information on the form in making their decision? And if so, where in the record does it show that they have disregarded that or erroneously refused to do that?
Well, 2 points, Justice Busby. Number one, I push back on the premise of that assertion that we have that duty. The text of 273.061, which is what we invoke here, does not include any such requirement, and we can't find any case involving that statute that imposes that requirement on us. But secondly, more directly, the Attorney General has been issuing guidance about the mail-in ballot statute to county clerks through press releases and other fora that make clear our view of what the law requires and what they should be doing.
Including specifically this issue about extraneous information on the form and that ought to be considered?
Your Honor, I don't know that we've gone into that specific level of detail, but we have said correctly that the county clerks have an obligation to reject mail-in ballot applications from voters who are not eligible and not entitled to vote by mail. And if a ballot application includes such extraneous information, that's a message from the voter to the county clerk that they are not in fact eligible to vote by mail. And under 86.001C, that application should be rejected.
Mr. Hawkins,
let me
go ahead, Justice Green.
Mr. Hawkins, are you then saying that if someone calls the clerk's office and says, I have a fear of the coronavirus, and so I don't want to go in to vote, can I just file an application to get a mail-in ballot as a disability? Are you not saying that you're going to issue an order to prevent the clerks from responding to that? Yeah, just go ahead and check off the disabilities spot.
Justice Green, if the clerk were to say that, they would be breaking the law and they would be violating their duties. And yes, we are asking the court to order that if the clerk is going to respond to that, that they respond truthfully. Anything less than doing.
You're attempting to order them to not, limiting their speech on that request.
Well, Justice Green, we're not saying that in that specific hypothetical, we're not saying that they have an affirmative duty to speak. What we are saying is that if the clerk is going to respond to that inquiry, they have to respond with the correct statement of the law, not an incorrect statement of the law. And so if the clerk were to tell that voter in Your Honor's hypothetical that they can claim disability and vote by mail, that's not correct. And that's what we're asking this court to prevent, along with the other items that I mentioned earlier.
And Mr. Hawkins, I wanted to ask you about the federal court decision yesterday out of Judge Beery's court. Assuming it's upheld, it doesn't preclude us assuming it's upheld, but it doesn't preclude us from interpreting the statute, but does it preclude the relief being sought? What's the impact? I wondered about that.
So, Your Honor, the Western District, as Your Honor just alluded, did enter this injunction last night. A couple of hours ago, we moved for an emergency stay in the Fifth Circuit. As far as I'm aware, there hasn't been a ruling on that yet. But Your Honor's question was, if it's not stayed, what happens? That should have no impact on what this court does. This court.
Yeah, but no impact on interpreting the statute. But what about on granting mandamus relief?
So the court should still grant mandamus relief. Now, I take it Your Honor's question is, on the one hand, there's a federal injunction from Travis County not to do something, and then what if this court orders the opposite? That doesn't go to whether mandamus relief is appropriate. That may go to whether Travis County's clerk is liable for violating this clerk's order. But that is a back-end question that should be resolved post hoc, not an ex ante question that we should resolve now. It shouldn't have any bearing on whether mandamus issues. In my remaining time, I'd like to shift briefly to some of the actions that the governor and secretary of state have been taking to ensure the safety of in-person voting. The governor and secretary of state have already taken concrete steps that we have outlined in our brief to ensure the safety of in-person voting, including expanding dramatically the period for early voting in person. The purpose of that, of course, is to reduce the number of times that people may be congregating in a polling place and to give voters many choices when they can go to the polls and when they can vote. And that, Your Honors, is just the start of the process. My understanding is that the governor and the secretary of state are actively looking at other measures that can be taken to ensure the safety of in-person voting. In fact, my understanding is that the secretary intended to issue additional guidance this morning, but of course there's substantial uncertainty in light of the injunction that Justice Guzman referenced a moment ago, and as a result has not yet done so. But all that is to underscore that the executive branch is fully aware of the need to protect the safety of in-person voting and is actively taking steps to do so. There's no need.
Do you know if masks will be required? Is that part of the plan?
I don't know, Justice Guzman. I haven't seen a copy of the final regulations. I am confident that that is one of the steps that's being considered. I can't make a representation to this court as to what will ultimately be required, but you can refer to all of the other executive orders, things like social distancing, masks. I'm sure all of that is being considered with an eye towards protecting the safety of in-person voting. I see that I'm out of time. Unless the court has further questions, I'd reserve 5 minutes for rebuttal.
Any other questions? Thank you, General.
Thank you.
We'll hear from the respondents. Mr. Brister.
May it please the court, Scott Brister with Hunt and Andrews Kurth. We represent Diane Troutman, Harris County Clerk, and I'm speaking today on behalf of all the respondents, the election officials from Travis, Dallas, El Paso, Cameron, and Harris County. It does seem a little more than ironic that judges and lawyers here are arguing today remotely about whether other people have to vote in person. The question today has nothing to do with extraneous information on a few ballots. As we indicated in our brief, they don't point out, this petitioner doesn't point to any evidence that somebody's approved a ballot that's in the wrong form. This is about, and in response to your question, the Solicitor General said, well, they're rejecting applications, no evidence of that. They're facilitating false information, in other words, their speech, and they're not complying with their oath to defend, which is their speech. So this is about speech and speech. I'm unaware of any example ever where the Attorney General has gotten an injunction or some kind of order that an independently elected official, and the Harris County Clerk is an independently elected official, what she can and can't say.
But what is their duty, though, under their oath and otherwise, to communicate correct information to constituents? What
Right.
is their obligation?
Well, they have a duty to explain the law to vote. Here's the key in this case. What the petitioner is saying is when people check disability, don't tell them that that doesn't mean the same thing as the ADA. Don't tell them that doesn't mean the same thing as Medicaid. Don't tell them, people assume this has disability in the election code has a definition, and the disability in the definition of disability in the election code has nothing to do with inability to perform major life function. It's a specific definition that's a physical condition. And there's no question lack of immunity is a physical condition that prevents you.
If I could take you back for just a second to Justice Guzman's question. Let's just assume for the sake of argument you're wrong about that. The clerks are wrong about how the statute works. Are you suggesting it's some kind of a First Amendment problem for this court to order the clerks to refrain from giving incorrect information to voters about how the law works?
No, and I mean, it's not entirely clear because this is an original proceeding, but we are all in favor of the court saying what this statute means, what disability means 84001. Can you claim this or not? We fully join that. We do not object to doing that. We want that done. But we think he's wrong on that, and we think the court should say so. So the two parts of that, of course, are so we made two arguments in our response. Number one, that the election officials have no discretion to deny applications that conform. If you check disability, we have to send out a ballot. I understand Solicitor General to concede that point, so I'll just move to my second one, which is that physical condition that may prevent you under 84001. There's no question that lack of immunity in a pandemic is a physical condition. In fact, if we had 30 million tests, we could find out whether all 30 million Texans have that physical condition. We could find it out for a fact. It wouldn't do you much good to find out, number one, we don't have 30 million tests. And number two, the question is on the voting election day, are you going to have it? That, of course, you can't tell. But that's an interesting point. Every part, I'm sorry, I think just, yes.
Yeah, wouldn't this lack of immunity also arguably apply to just the everyday average flu?
No, because it's that where the sickness or physical condition prevents the voter from appearing at the polling place on election day without the likelihood of injuring the voter's health. Now, my view, as we explained in our brief, likelihood is a balance of two things: the probability of injury, and the severity of the injury. So,
But, excuse me, Mr. Brister, but how are we ever going to get to that point if the clerks cannot investigate whether or not their claim of disability is valid? How do we ever get to this?
well, I agree that apparently the Solicitor General thinks if you volunteer, two things, if you volunteer something on the form, then that disqualifies you. I don't think you have discretion to disqualify people for something on the form. We submitted the form in the bench exhibit, and it says to check one or the other, disability, absence, etc. There's no way, and in fact, the only requirement, you can make up your own form. You can apply for a ballot voting, absentee ballot, and vote by mail on your own form. All you have to do is state the ground of disability. What the Solicitor General is arguing about is the reason for the ground of his disability. You don't have to state that. In the bench exhibit, I gave you the laws from 1935 forward. You've never had to explain that. The affidavits starting in 1935 and continuing till they stopped doing affidavits in 1985 just says, you say, I'm unable to appear because I'm disabled, period. And you're exactly right, Justice Lehrman. How would you know whether somebody's going to, how would a clerk know whether you're going to be absent from the county? They would
Mr. Brister, do we look at the degree of likelihood? If the curve is flattening, as some say, then the likelihood of you getting infected during the early voting process with double the amount of time, 20 days, disinfecting the machines, wearing masks, maybe wearing gloves, is different. How does that term work as we interpret and look at this statute? It just says, without a likelihood of needing, assistance or injuring the voter's health, but that likelihood changes over time when you're talking about a generalized fear of the COVID-19.
Well, there's a lot of answers to that.
Right. I'm sorry about that.
No, that's all right. Let me start with saying every ground of disability is an opinion. You're saying in advance, I expect to be absent from the county. You're saying in advance, I expect to have difficulty or have susceptibility in advance. You have to say that in advance, even confined in jail. I mean, how do you know? Maybe they'll let everybody out of jail. Every disability that you claim, every ground is an opinion about the future. And whose opinion do we rely on? We can only rely on the voter because nobody else knows. when they're going to be out of town. Nobody else knows what their individual health condition is. And the election clerks have no way to find out. Now, what you should be, again, back to what you should be telling people, should we be telling people the correct definition under the law? There's no question that major life functions has nothing to do with whether you're disabled and voting by mail. But when normal people who aren't lawyers and are not, and the Attorney General is threatening, don't tell them what the actual definition is because I disagree with it. That's the problem. Because that it is your opinion. Until somebody's fixing to answer the question. I'm used to the Zoom things where somebody raises their hand, but I know the court doesn't have to do
It
that.
sounded like you were going to answer Justice Devine's question by saying that lack of immunity to the common flu would not be a qualifying
Thank you.
condition.
Yes.
Talk about
So as we explained, we gave several examples in our brief in pages 9 and 10. Likelihood often means where you balance the severity with the probability. Now, if the severity is, I can't do this because I might scrape my knee at the polls, or I might catch a cold. Most of us would say, even if the probability is very high, the injury is so minor, the likelihood of injury to your health is very small. On the other hand, and a reasonable voter would not claim disability in that circumstance. This obviously is a different circumstance. If the severity of injury is high, the probability does not have to be at high. And let me give you two quick examples. When people say fear of COVID, if I say, I'm afraid my days of hanging Christmas lights on the roof are coming to an end, and I've never said that and won't because I love hanging Christmas lights on the roof. I'm not saying I think, I'm really afraid. I'm talking about my emotion. I'm just afraid. I'm not afraid. I love to do it. What I'm saying is the likelihood of breaking my neck at some point says I need to pay somebody else to do it. And I would be a fool if I said, well, the likelihood's got to be 50-50 of breaking my neck before I'm going to stop. This is something we do in products cases. This is something we do in malice and exemplary damages case. We balance the probability with the severity of injury. And that's what ought to be happening here.
I didn't see a case cited to that effect. We've said likelihood is probability. We've also said that risk, as distinct from likelihood, is a balancing of the magnitude of the harm and the probability it's going to happen. But is there a case that says likelihood is the same thing?
Well, I'd have to look back at my brief and see exactly what we said. I would say this. For instance, if a disabled voter says, I'm likely to need personal assistance because I don't want to be embarrassed, I don't want to face steps, I don't want to run into any of these problems, would we require them to say, no, you got to have 50% certainty that's going to happen before you can vote by mail?
But on the other hand, wouldn't we say to a voter, who says, I'm afraid it might be a thunderstorm that day, and I don't want to get struck by lightning, so I'm disabled. It looks to me like either one of those things could happen.
Well, our clerks are not telling anybody anything about that. My client is not saying anything about if you're afraid of a cold, you need to stay home. We're not telling people to stay home. We're not telling people what they should or shouldn't do. We're not promising them they're going to be safe or we're doing everything we can to make it safe. What we're telling them is exactly what the statute says. If you have a physical condition that you feel prevents you from voting in person because of a likely injury to your health, you may claim disability. That is exactly true.
But are you also, Mr. Brister, the allegation is that the election officials are going one step further by saying that if you're afraid of getting COVID at the polls, then that qualifies as such a physical condition. Are you saying that none of the clerks are saying that?
I don't know what all the clerks are saying. I know I haven't seen anything indicating that in the petition, But I would say this again, I'm afraid of this or that. That is a colloquial expression or a shorthand for saying, depends on what they're saying. If they're saying, I just have an emotional fear, I don't disagree with the Solicitor General that emotional fear, we shouldn't tell people if you're just afraid, and you just want to cower in your home, that's disability. What we want to tell them is if you have a physical condition, for instance, if I say, I'm afraid I'm not going to say everything I want to say in my 20 minutes, that's not a statement about my emotional condition. That's a statement about how many things I want to say. And if people say, I'm afraid of catching COVID at the election, what are they saying? They are saying, I fear the probability, I have a physical condition, lack of immunity, that the probability, the likelihood of me injuring my health, in my opinion,
Right, but
renders me disabled.
What I'm hearing you say is that your clients want to be able to tell voters that does qualify as a disability, which justifies mail-in voting. Is that correct?
If what they mean, my clients want to say,
no, I'm assuming they mean what you're trying to describe, the difference between being afraid you're not going to get it all in within 20 minutes and being afraid that because you have no immunity to COVID, you have a physical condition that creates the likelihood and so on. I'm with you. I'm assuming that. What I'm trying to clarify is this. On the one hand, you've told us that your clients want us to answer that question in this case. They want us to decide whether the fear of getting COVID qualifies as a disability. And it seems to me there's only two reasons we should ever decide that in this case. One is if it's necessary to consider whether granting relief prohibiting conduct, which here I think the only possible conduct would be if a voter writes in the reason for their disability instead of just checking box number 5, and yet none of the forms provide any room to write that in. So I just don't see how we get to conduct. The second reason we might think that resolving that issue is necessary in this case is because they want us to stop your client's speech. And what I'm getting at is, are you saying, yes, your clients intend to engage in the speech that the Attorney General wants us to prohibit?
No, I would discourage the court from trying to write a transcript of what independently elected officials can and can't say. And I started off with saying that. I will say what my clients want to say is the definition of disability in the election code is that you do not have to be in a wheelchair. You do not have to be on Medicaid. You have to have a physical condition, which can include lack of immunity to COVID-19, that prevents you because of the likelihood of, we want to say precisely what the law is.
Let me ask.
Right, but if we disagree that that's what.
Go ahead, Justice Boyd.
If we disagree that that's what the law is, you're agreeing that we ought to say so in this mandamus proceeding.
Sure. Yes.
Okay. That's all I'm trying to clarify.
But I am not saying you need to ban afraid. I'm afraid of COVID because for the reason I just explained. That's a shorthand for saying what I think the law says.
Mr. Brister, I want to be sure that I understand your definitional argument. It sounds like the argument is that a risk of sickness qualifies as a physical condition. Is that a fair summary?
Well, no, 2 steps. First step, it's the opinion of the voter that counts.
Well, right, but the voter's opinion about the physical condition, about the risk of sickness is what it sounds.
I'm not arguing for anything other than what 84002 says, which is a physical condition that prevents the voter without voting in person without injuring their health.
That's 84002 also says sickness or physical condition. So if we interpret physical condition to mean risk of sickness, then aren't we changing the legislature's choice to say sickness rather than risk of sickness?
No, well, I think it would depend, this is unusual circumstance. Let me make it clear. I don't think anybody's ever taken the position that we need to tell people to claim disability because they're afraid of catching something. We cannot ignore where we are. We cannot ignore where we've been locked down for 2 months. We cannot ignore global pact. We cannot ignore that this year the elections are different than they have been at any time since World War II. This is a different climate with a different kind of disease, and the likelihood
to be clear, the governor and the legislature can't ignore that, but we can't ignore the language of the statute. Are you asking us to ignore the language of the statute because of the current circumstances?
Not in your wildest dreams. I would never suggest that. This is what our position is, and we think we're right. We think the court should say we're right, that we are entitled to explain to the jurors, because of the risk that to voters, the risk that they will think disability must be something more strict than it is in the election code. We think the election code has been for 85 years broad enough to cover the once in a century global pandemic.
Is there any reason to think that the likelihood of harm from coronavirus resulting from one trip to the polls is a whole lot different than the likelihood of harm resulting from one trip to the grocery store?
You'd have to ask the doctors about that. Again, if people are anything like me and probably you, this is all people have been reading about for 2 months, and they're reading all kinds of opinions. The bottom line is, who has authority to check disability box and who doesn't? And the answer is the voter does. Does the voter have a right, do election officials have a right to tell them what the right standard is, or must we be silent and let them assume the wrong definition?
You said
Mr. Brister.
the likelihood of harm, and I'm just trying to figure out how we gauge the likelihood of harm. I mean, you're talking about a group that's under 65. We know that the risk to them is much, much lower than the group over 65. So there's already that aspect of it built into the law. I mean, how can we gauge the likelihood of harm from one trip out of the house?
And if the question is, do you have to send a ballot to them if they check disability? We don't have to. If the question is, what kind of opinion should we write, what clerks can say, I would discourage the court from trying to write a transcript of what other elected officials can say. If they go beyond, if they go too far, that's one. But everything you've seen in the petition that quotes what they say, they're saying exactly what I'm saying. They're saying it's a physical condition, and if you think there's a likelihood of harm to your health, you are entitled by the Texas Election Code to claim disability, and nobody can tell you you can't.
Mr. Brister, let me ask you just one thing, and that is with regard to following up on Justice Blacklock's question, and that is comparing going to the poll with going to the grocery store. The reality is people have a choice about going to the grocery store. They can order it, it can be delivered. There's other ways they can get their groceries. And if they check disability and they're denied that, they won't have another choice. Does that reality factor into the analysis?
Well, it does. I mean, all the things that will be different about voting this year. Voting was going to take longer this year, regardless, in the general election, because you can't do straight ticket voting. And a huge number of people were just walking in straight ticket voting and leaving. There's been more polling places than there are going to be this year because, and we've cited this in our brief, you can't use a nursing home as a polling place. Those are off limits. You can't use a small clubhouse at an apartment complex or a church basement because you haven't got room for physical. You're going to have to vote in gyms, which means you're going to have to combine polling places, which means there's going to be long lines where all the election officials have to wash their hands all the time, where the voters are washing their hands all the time. Somebody's cleaning the restrooms after people wash their hands. This is going to take a while. This is not the time to adopt a restrictive definition that says, everybody, you better get out there and stand in line however long it takes, because the effect will be, as we all know, they just won't vote.
Any other questions? Thank you, Mr. Brister. Ms. Nicholas, we'll hear from you.
please the court. I represent the Dallas County Elections Administrator, Tony Pippin-Spool. The state bases its mandamus action on two things here against the election administrator: a resolution passed by the Dallas County Commissioners Court, of which the election administrator is not a member, and a statement of fact made by the election administrator in an email. In essence, the state has asserted that the election administrator has made statements representing how a voter can vote in regard to COVID-19. However, there is no such support that any such statement has been made by the election administrator in the record. The facts are that the Commissioners Court had a meeting wherein one commissioner sponsored a resolution that supported, not ordered as indicated in the petitioner's brief, that due to COVID-19, that voters should be able to check the disability box on the vote by mail application. The state attempts to conflate the actions of the Commissioners Court to the actions of the election administrator. The sponsor of that resolution—
Ms. Nicholas?
Yes, Your Honor.
Just because you only have a few minutes, I wanted to just make sure. I read all the briefs, the responses of all the different respondents and interveners, and I thought all of them argued that we should not take up this mandamus case at all. We shouldn't decide the question for a lot of reasons, one of which is what you're just now describing, which is in essence, all the state's concerns about what the clerks and officials are going to do are unfounded, that if anyone's out there saying the wrong thing, it's the commissioner's courts, not the officials, and so on. But then I just heard Mr. Brister argue, no, we should take up this mandamus and we should answer the legal question, because at least his client, the Houston clerk, and he thinks others want to be able to say the things that the state says they shouldn't be able to say. Are you agreeing with Mr. Brister, or are you arguing that we should not take up this case?
Your Honor, Mr. Brister does not represent Dallas County. It's the Dallas County's position that the election code does not vest her with the authority to determine what constitutes a disability, which I believe the state and everyone else is in agreement with that. That is for the legislature to decide, and in compliance with the statute, the Secretary of State. So in regard to Mr. Brister's statement, in regard to his representation of his clients, we have nothing to state in that regard. We are defending in regard to what took place here, and the fact that there is no facts of any action taken by our client that would justify jurisdiction over her in this mandamus action. Apparently, the state is in essence asking for an advisory opinion as to her client, or basically a declaratory judgment action in the guise of the mandamus to interpret the statute. Here, the record is completely deplete of any other action by our election administrator other than this specific statement. As election administrator have done in the past, we do not investigate the reason or require further explanation for the disability if the application is marked disability. The state has indicated it agrees with that statement. So if the state agrees with that statement, and that is the only action on the part of our election administrator, how can that be the basis of a mandamus action against the election administrator? What the state is trying to do is conflate the actions of the Dallas County Commissioners Court with that of the elections administrator to create mandamus jurisdiction. In addition to that, Your Honor, there is absolutely no ministerial act that has where the state can point to where the election administrator has not complied with. There's no indication that our election administrator has done anything other than that statement I just quoted for this court. So,
Ms. Nicholas, I found all of that very compelling in your briefing, but I'm kind of stumped over what to do now about the fact that some of your co-respondents seem to think that we should go ahead and decide the issue because their client, who is also a respondent in the case, wants to be able to say the things the state says they shouldn't be able to say.
Well, for Dallas County election administrator, Your Honor, we ask that mandamus be denied. As to that definition of disability that Mr. Brewster has argued, I believe the Harris County, et cetera, are in the best position to put forth the arguments on that matter. But as we sit here right now, Your Honor, the election administrator has not taken any action whatsoever in which to justify the exercise of jurisdiction over her. And the state cannot point to any such evidence in the record.
Any other questions? Thank you, Ms. Nicholas. General Hawkins, you have 5 minutes for rebuttal.
Thank you, Mr. Chief Justice. Just a few points in response.
Mr. Hawkins, would you begin with addressing the point about the Dallas election administrator and the fact that you're conflating the statements of allegedly of Commissioner's Court with her own? Would you start there, please?
Sure, Justice Guzman. Let me make a couple of points about that. First, in pages 8 through 11 of our mandamus petition, we include statements from the respondents indicating that they intend to promote and or enforce an incorrect understanding of the law. If other Dallas County officials have also made misstatements and we haven't named them, that doesn't impact the availability of mandamus relief here in light of the statements that we've documented on those pages of our mandamus petition. And that goes for other counties too, Your Honor. I'm delighted.
Mr. Hawkins, were those statements based on the Travis County injunction while it was in force?
No, Justice Busby, because the Travis County injunction was only in force for literally a matter of hours. We immediately superseded it by filing a notice of appeal to the third court, I think something like an hour after it issued. And then last week, the 14th court briefly resurrected it. But of course, that was after our mandamus petition was already on file. I'd like to touch briefly on the point of agreement between Harris County and the state. We are delighted to hear that Harris County agrees that the court should consider this petition and resolve the meaning of 82.002. We very much agree. There is statewide confusion, and this court is the only one that can definitively resolve this important question of statutory interpretation. But I'd like to go through just how—
Mr. Hawkins, in resolving that question, are we to interpret the statute in a way that favors disenfranchisement of an eligible voter or enfranchisement of an eligible voter, one who's qualified to vote in the election?
Neither, Justice Bland. There's no authority that's operative now that goes either way. This court should interpret the statute consistent with its plain meaning. And I'd like to illustrate just how wrong Harris County's interpretation is. Harris County's reading of the statute puts the cart before the horse. They say that physical condition is defined by the subsequent statutory text that comes after the word that. But that argument violates basic rules of statutory interpretation. The word that marks the start of a subordinate clause. It cannot take precedence over or define the meaning of the independent clause that precedes it. So what that means in the context of this statute is we first have to ask whether there's a sickness or a physical condition. And only after—
Mr. Hawkins?
Yes, Justice Boyd.
Today we received amicus briefs from physicians and healthcare workers who say that the lack of immunity to a virus like COVID-19, in their opinion, is a physical condition, that physically they lack immunity and therefore is a physical condition. Don't we have to give some credit to that?
No, Justice Boyd, you should give no credit to that. The question is not what physicians think about how the legislature might have written the statute. The question is, what words did the legislature choose? And what do those words mean? Now, the definition we've provided on page 13 of our brief speaks of a condition as a medical problem. And that makes sense in light of the fact that we've got a statutory term with the heading disability. As I indicated earlier, no one would say that a generalized lack of immunity to disease makes someone disabled. So in context, the definition that the amicus brief put forward is not correct and cannot be what the legislature intended, because again, that would sweep in every voter in Texas. Now, Mr. Brister made much of the word likelihood in the subordinate clause. I would like to stress that this court does not have to reach that word and does not have to reach that subordinate clause at all, because that clause has no meaning or no impact on the meaning of sickness or physical condition. First question is whether there's a sickness or physical condition. We only get to likelihood if the answer to that question is yes. And that is the fundamental error in the mode of statutory interpretation that Mr. Brister put forward a moment ago. And as I said a moment ago, his reading would have no limits. Anybody would be eligible to vote by mail. I'd like to touch briefly on the conduct versus speech point. Mr. Brister concedes that there's no First Amendment problem with what they're seeking. I'd like to stress that we are targeting conduct, both the conduct required by 86.001C and the conduct to provide voters with correct information as provided in Chapter 84, in 276, and in Article 16 of the Texas Constitution. These election officials have a duty as part of their job conduct to give voters accurate, not misleading information and not encourage them to submit false applications for mail-in ballots. I see I'm out of time. Unless the court has further questions, we would ask that mandamus be granted.
Any other questions? Thank you, counsel. The case is submitted and the clerk will adjourn the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas now stands adjourned.